I know that I'm live, everyone. I'm waiting for Beth to join in and host this thing. So I'm waiting for her to jump back on. Sorry, everyone, for the technical difficulties.
Sorry, I don't know what happened there. My apologies, folks. Technical glitches. Apologies, Colin. Welcome. Welcome. Well, it's a good way to start because things in the music business never quite go the way you think they will, right? Tonight, we are very fortunate to have a very distinguished entertainment attorney who is a specialist in intellectual property. And he is a wonderful and well appreciated lawyer. He has been a super lawyer for 2020, 2018, and 2019, and has a lot of impressive credentials. But more importantly, he knows the business of creators inside and out. He works with bands, he works with producers, he works with labels, and he's a guru of all things agreements and what you need to do to protect yourself and your rights and to get paid. So, Colin, you want to tell us a little bit about you, how the clam chowder is in Boston, or lobster claws?
Those are really bad accents, but that's okay. Well, I'll let it go. Okay. Yeah, thank you. I appreciate the kind words, and I like guru. That's nice. So yeah, my name is Colin Mara. I'm a entertainment lawyer here in Nashville. I founded my company Whiskey Ghost Entertainment Law about 4.5 years ago. As Beth said, I'm originally from Boston. I grew up there, practiced at a firm up in New Hampshire for a couple of years before moving down here, deciding to start my own thing down here. And I actually initially started out in artist management here, knowing that I was going to also take the bar and practice on the side. But as I'm sure all of you know, and the reason you're here is there's such an unbelievable demand for the need for legal representation for music creators here and small businesses that it took over my life, and I absolutely love what I do now. So what I do is I represent independent musicians, artists, songwriters of all different types. I represent small businesses, record labels, publishers, distribution companies of all types in every facet of the music industry, usually involving contract drafting, contract review, negotiation. I also do trademark registrations, business formations, and everything in between. So what we're here to talk about today is some of those pitfalls that come up on the copyright side, which obviously gets thrown into those copyright or those contracts that I'm drafting on.
Thank you. Wow, that's a lot of things to stay on top of. And I know as a creator for many, many years myself that having a good entertainment attorney to help you navigate this process is absolutely essential, especially when it comes to your career and your livelihood. So let's start out by talking about the kinds of agreements that creators, whether you're a songwriter, producer, you're in a band, what are the primary agreements that you think are essential for creators to know about?
Sure. So, I think what a lot of people here or know about are the split. That's when you're writing with someone else, co-writer agreement. That's simply just explaining the difference in ownership between the composition that we wrote together. You're usually going to get 33% together. But people don't understand is, that is usually going to address the underlying composition. Refresher on copyright, if you guys don't know, is that in every song that you hear on radio, there's two entirely separate compositions that are contained within that. It's the sound recording that you're hearing in the underlying composition. So when you're doing the split sheets, you're addressing the underlying composition. You're not addressing the sound recording in any way. So what you want to do when you're recording these things is you want to take that next step and draft up what's called a collaboration agreement. And what the collaboration agreement is going to do is not just explain the splits and royalties, but it can also explain who's going to be able to exploit the copyright. And one of the biggest issues or misconceptions that people have is, when people are looking at a copyright and you think that you're going to give 5% to your friend who is, I think we just lost Beth, but that's okay, I'll keep going. When you think you're just going to give 5% to your friend who sang backup vocals on the on the sound recording, you're going to entirely own the sound recording, have control over it. Well, without an agreement, fall rules under the Copyright Act, if you're a joint author, whether you own 1% or 99%, you're going to have the same rights in that copyright, which means you can go out and exploit that copyright. What you want instead is a collaboration agreement that's going to say, yes, you get 5% of the royalties. However, I'm retaining full exclusive rights to administer and exploit the copyrights in any way. You have no rights in that sense. Essentially owning the copyright. So that's going to come up in a lot of different assets. It can come up in that underlying composition, like we talked about. It comes up a lot in master recording. When it comes up in the master recording, is all the times that I'm talking about the producer agreements, or if someone is, like I said, singing backup vocals, you want to give them or two in scenarios like.
Well, to that point, can you say just a couple words about the way, because this pertains to the ownership of the sound recording, can you explain why this is important for Sound Exchange, which collects, pays people based on the actual sound recording royalties, correct?
Sure, yeah. So Sound Exchange came along in one of the newer acts. So what you guys have again is when we talk about the two separate copyrights, we're talking about the underlying composition and the sound recording. You have two entirely separate revenue streams that are generated from those. So for example, when you hear a song on the radio, on the regular terrestrial radio, in your car, the only royalties that are being paid out are from the underlying composition. So it's being paid out to the publishers and the songwriters. No one on the sound recording is getting paid out. The public performance royalties are being paid for that. Okay. What happens on the master recording side later on is when digital streaming came into play, they finally said, okay, we'll start paying royalties for the digital performance of the sound recording. So Sound Exchange essentially acts as your your PRO, your ASCAP and your BMI for the sound recording side, but it's only for your internet radios. So what happens with your collaboration agreements is, say you're giving 5% to somebody on the sound recording side for all their the royalties that are coming in. What's going to happen is they need to, I believe, still right now, this is going to change. If it hasn't already, it's forever changing. When you sign up for the Sound Exchange, what happens is you have to file what's called a letter of direction, saying, okay, this is my copyright that I'm exploiting. 5% of Sound Exchange royalties that are being paid are going to be paid to John Doe. And then they're going to, and then Exchange will pay them directly. Now, in the future, because the Music Modernization Act, I know I'm throwing a lot of it. Okay, so if people have questions, if you're commenting to that, please do, and send you contact information. But with the Music Modernization Act, there's they're somewhat changing that, and they're giving producers and people who perform on these the ability to register directly with Sound Exchange, just like someone can with their own PR code if you're getting a piece of composition. So I don't believe it's changed yet. I'm not sure. I really need to look that up. But if anyone knows, please insert it in the comments.
Well, the MLC went live in January, the Music Mechanical Licensing Collective, which, for those of you who may not know, was a big consortium of music publishers, rights holders, all the players, the advocacy organizations from the Nashville Songwriters Association to the national publishers, all the big people got together so that they could aggregate the ownership rights of creators and to get that information all in one database. Previously, there were over 40 that people were pulling from. So it's very important, if you have songs, that you should check out the MLC.com. They have lots and lots of helpful seminars. They teach you how to register and make sure your works, make sure, all the things about your real legal name. And I'm sure Colin's going to talk about this a little further, but what he's referring to is this massive slate of legislation that is coming into play finally. Most of the laws that impact intellectual property are over 100 years old and were written before digital, written before a lot of things happened. And, the balance is definitely shifting. But that being said, the Indian market is the largest growing market globally in the entertainment space. So you absolutely have to know what your rights are and what you are agreeing to when you sit down to work with a producer. And I think because most people from our community are creators who do work with producers and our band members, maybe we should start with talking about band and collaborator agreements and why they're different, and what makes it different, and what are the red flags and what are the must-haves.
Yeah, so I guess I can kind of break it down into, each level of what you're adding to an agreement for all these different kinds of agreements. So, in its simplest form, when you're talking about just splitting up the royalties, that's the split sheet. Everyone's just going to split the royalties, and everyone's going to have equal exploitation of the composition, right? So, the most basic form. Then we start talking about higher agreements, okay? That's kind of a hybrid between the collaboration agreement. And what you can do is, if someone's playing guitar on your sound recording, you might not want to give them any royalties back, or maybe you will. But what you want to do is say, look, I'm just paying you $500 for the day. So you're not claiming any, but I don't want you claiming any ownership of this. You want to make sure all your I's are dotted and your T's are crossed. So anyone who's contributing any kind of copyrightable material to your sound recording, you don't want them to come back and say that they can claim ownership to it. If you have made for hire agreement saying, look, in exchange for $200, you performed on this, you're giving up any rights to any copyright ownership to this. That's your work made for hire agreement. So those are kind of your two basic ones, right? One is splits and everyone has equal ownership of the composition. The next one is you pay the person and they don't have any ownership in your copyright, right? Then we're talking about the collaboration agreement we just talked about, which is, you get back end, but I might have the ability to exploit that copyright, right? That's kind of a hybrid between those two, okay? And then when we start talking about band agreements, they're kind of blending all of that in and adding a lot more in it, right? Because what you're doing is you're creating what essentially a perpetual agreement per band. You're defining, everyone's rights, who just like a business, just any any solo musician should think they're a business, but certainly any band that you know you're going on seriously together, you need to think of yourself as a business and you need to act as a partnership and define, who's contributing money. How are you guys deciding when that money is being pulled out? Who's owning the intellectual property, which is the composition, which is the sound recording, which is the band name and the logos and all of that. You have to decide on that. You need to decide on voting on big decisions, entering into a record label, entering into a loan, buying a car for the band. What happens how do you vote someone out? What happens if they get voted out? You have to pay them out, things like that. So you start adding in a lot of other factors into a band agreement.
But this also is something that you recommend everybody who is serious about creating their band and making a living from that band, from their music. You recommend that they answer these questions early on the front end and discuss them, and then put it into a written document that they can have reviewed by someone like yourself, correct?
No question. I always say, if you're having people switching in and out of your band and you guys haven't played much, then, it's not worth it. It's not worth doing. You still might want to have a collaboration agreement so everyone kind of works out. Songs are being created, right? So you still want to work out that. Full band agreement, it just might not be worth it. People are shifting in and out. But once you understand, look, these are the 4 men and women we're in it together and we're going for it. The earlier the better is what I always say. I mean, I'm sure everyone here has heard horror stories of bands that are worth millions and millions and millions of dollars, and there's all kinds of issues. You want to do it earlier. You want to think of yourself as becoming $100 million band, and you want to work out that agreement now so it doesn't become an issue down the line. And especially because you want to get those conversations now, because there might just be misunderstanding. Some drummer who doesn't really partake in songwriting much might still think he's getting it cut. When the other 2 guys who do the songwriting might be thinking, why do you get a cut? I would think throw him a bone if he's, you want this guy in your band forever. But, you got to start having those conversations, because you don't want to go 2 years into it and everyone's making $100,000 or something.
Well, that leads into my next sort of realm of questions is, very often bands get together, they're friends, some of the members are friends, and they've been writing together, and then they hire, the rhythm section around it or whatever, but not everybody writes songs.
Mm-hmm.
So that can also become complicated when a band starts gaining momentum and interest. And let's say, you have some A&Rs or you have some publishers out there, and they want to sign the writers in the band. They don't necessarily want the other people that are not writing. And how is there a separate agreement that like an attachment, an addendum to that contract that's very clear about stipulates, let's say Joe and Sam are going to be signed by BMG or Broken Bow Records. So their copyrights will be with that entity and not with the band, right?
Yeah, well, there's a million different variations to that fact pattern, right? I mean, if the band has already created an agreement and everyone's sharing in those copyrights already, they can't transfer the entire copyright to the record label without those 2 band members. I mean, they can't transfer. If me and you own a copyright together, and then, Atlantic Records comes to me and wants to sign me with that copyright, I can't give them your share. I just can't. You know, they have to bring you in. They have to bring your share in at least. You know what I mean? They can sign my share and they can sign me. So, you know, but there's a lot of different issues that would come up there. Now, if there's no agreement, it can get a little dicey. I would assume that for the most part, I mean, if especially on the record label side, they're going to want to sign the band. I mean, they're not going to want to sign two people unless the person has historically already been successful and they say, let's go do the solo career. But again, that's why your LLC is going to define what happens there. That person's going to leave the city. They're going to withdraw from it. And then what happens at that point? So you just have to let your band agreement define what's going to happen in that case.
What about co-pub deals? Like, I'm asking this as a question because I'm not sure I know the correct answer, but do you ever see, you know, with independent artists, because there's not as much money usually involved in the deal initially with the creators, is it likely that one member might get a co-pub deal? Or is that once again the whole band based on what you agreed on the front end?
They certainly could. The only issue is if they're trying to bring in the copyrights, you know, they're only going to get the share that I can definitely see it more common on the publishing side if they know that you know, one person is a good songwriter, because they might be writing compositions for people outside of the band. Now, I know someone specifically who was in a band and was writing for an entirely different genre for a publisher, completely outside, and it was carved out of the band agreement. It just didn't touch the band agreement. You can work those things out as well.
Well, I mean, there are people like Bruno Mars and Ed Sheeran and, you know, Gaga and all kinds of Harley, is that his name? Anyway, there are lots of Halsey. There are lots of people that are in an entity, but they write with a lot of people, and sometimes they're brought in on a project as a, you know.
Of course, yeah, and there's a million different ways to do it. I mean, there's a million different ways that, you know, I'm talking the traditional rock band but there's a million different ways to do it, especially, you know, nowadays. The traditional pub deals, the traditional label deals aren't around just as much as they used to be. People are getting much more creative than they used to be. So, you know, you can get creative with however you want to structure those things. But for sure, you know, if a publisher understands that this member of the band is a true songwriter and they want them writing to pitch to, you know, other artists, there's no problem in them signing it and signing with them. Now, trying to bring in the copyrights from the band into the umbrella of the publisher, they're not going to be able to bring in everyone's share of the copyrights without an agreement with each side.
So another question to that point: if a band has a manager, is the manager negotiating on behalf of the band, or are you as their attorney negotiating with the label or publisher, or is it both of you? And what can someone expect to be the most effective?
Well, certainly you want an attorney involved at some point, no question. The manager may have, again, every scenario is going to be different. The manager might have the connection to the label or the publisher. You know what I mean? So they might be negotiating or setting up the meeting and all of that. You know, sometimes I get brought in after the material terms have already been put together, or the agreement is already, you know, it's sent to the band or the artist, and then I see it. Other times I'll be brought into a meeting. So there's a lot of different scenarios that come up, but certainly under no circumstances would I say, yeah, just let the manager negotiate everything. Now the manager, especially an experienced manager, is going to understand what are good terms and what aren't, so you can negotiate those material terms. And for some situations, I would say go ahead and you start negotiating those material terms before bringing in an attorney. Now, if you want to sit down with major labels, I would probably say bring in an attorney before you start doing that, because you don't want to, especially if you don't understand, and if a manager is not experienced, you don't want to say things that you don't mean or have to take back later because you go, oh, that is a bad deal. Never mind. My attorney told me later on. You know what I mean?
So at what point do you recommend a young act or a young artist or songwriter, whatever, the creator, at what point do you feel is optimal for them to engage with someone like yourself, to start talking? Like, obviously you want to file your copyrights, but people are looking at you. Is there a recommended time you think they should engage in getting the process going, so that when something happens, you have your boilerplate kind of foundational discussion points or whatever?
Yeah, that's a great question, and everyone asks that, and there's no set answer. The only real answer, the hard line answer, is if you're putting pen to paper or drafting something up, certainly find an entertainment lawyer. Other than that, when we talk about these collaboration agreements, you may want to reach out to make sure that you have a proper collaboration agreement, a proper work for hire agreement that you can use. Other than that, the best thing that you can do is, if you feel that you're going to start collaborating with a lot of people, you're setting up a lot of meetings, and you just feel that a representation is going to be needed, I would reach out and start, connecting with entertainment lawyers that you feel comfortable with. That's one of my things one of my missions in my company is to really allow legal access to independent musicians and small businesses, because I think that they're just so intimidated by making a phone call or shooting an email to find out, what it would cost or what the process is. And, I don't want, it shouldn't be like that. They shouldn't go without at least knowing what their options are as far as representation before they're signing anything. They shouldn't just assume that they can't afford it or not make that phone call. I just feel like they just think if they call, they're going to get a bill in the mail from the attorney.
So you do go about things a bit different. So for our creators out there, what does an entry or entree into Whiskey Ghost Entertainment Law look like? Do you prefer people call you, email you, both? So to get the process started, even if it's an exploratory process and they may not have all their ducks in a row.
Yeah, certainly phone call is fine. Email will probably be easier to respond to. And then I have a free introductory meeting, 15-minute meeting that you can schedule. You don't even have to have anything specific that's going on. Just schedule it, and I'm
putting this in the chat. So how do they do that? A 15-minute scheduled call? Where should
you
they
just go
email?
You go to whiskeyGhost.com and you just go to contact and you just schedule it. It's in the calendar right there. And I'm up for I like meeting people. I like getting to know everyone in the area and learning what they're doing and checking out their music. I'm a music fan. So I'm up for, grabbing coffee with people if I have enough time to do so. The week is crazy. So, it's always worth reaching out, getting comfortable with your attorney, and without diving too much into the weeds, how I usually go about it is if you do have a specific item that you need representation, we work through, pricing, either flat rate. If I can do that for you, then I will. And that's, people always ask, well, what's your flat rate? It really depends on what's going on. And then hourly rate is going to depend on if you're a business or not. And we can talk about that offline, but I try to work with everyone as best.
Well, we always say one size doesn't fit all, because creators are unique, and their needs and their growth trajectories are all different. And so it is I would say that the most important thing is finding the right fit with someone like yourself, to make sure that you can communicate easily, you do understand what the objectives are, and to have somebody you trust. I know this is an old word, but there are shysters out there that, so what do you have advice for people to that point about what are red flags if somebody's going to contact an attorney? What are some red flags that let a creator know that this is probably not a good thing to look into or pursue? Because I know there are some.
Yeah, that's a great question. On the entertainment lawyer side of things, the only thing that I would say as far as entertainment lawyer is do your research. Research them, check out their reviews, see if you know any of their clients. People ask me for my clients. I have some listed who wrote reviews for me. You're not supposed to just disclose clients. I mean, there's confidentiality, so I can't give you everyone that I have. You know what I mean? So, but do your research as best as possible. See if they actually are an entertainment lawyer. Don't just use your uncle's real estate lawyer who doesn't do it. Now, they might be new, and that's fine. Someone who's new, everyone's been new at something. That's fine, but don't just use someone who's never done it and is going to do a one-off thing for you. That's, as I'm explaining right now, I mean, entertainment law is very, very, very tricky. I mean, copyright law in general is very, very tricky. So you want to make sure that it's someone who's well versed in it in some way, shape, or form.
So to your point, we have a question in the chat about working with your sets of clients. Are you seeing all types of genres that come? Lots and lots of different types of music are now relocating to Nashville or establishing their bases here. And, let's say you're a hip hop artist, and that structure of production and co-writers is wildly different for the most part than a typical country music traditional thing. Do you recommend that they seek out someone who specializes in that, or is it okay to just sort of find the right fit? Because I do know that in many instances with younger hip hop artists, they don't realize that the producer is really owning everything, and the producer is the one getting signed to the label, not the artist. So
yeah, and a lot of times in the hip hop realm, I mean, there's more fraud in the hip hop realm for some reason than anything else. But I mean, going back to the question, I don't think that anyone really specializes in a specific genre. Now, there might be some entertainment lawyers who are more reputable because they've, represented famous country artists or famous rock artists. I represent all different genres, and I know the difference between all the different genres and how they operate. And that's it's actually funny that that question was brought up, because a lot of the times that's what's brought up about producer agreements. Like, everyone asks, well, what's standard to give a producer? And
yeah, that's my next question. So how did you know? Do you have a crystal ball?
Yeah, exactly. Everyone asks me that. It's one of my most popular questions is what's standard to pay a producer up front and on the back end. And there's absolutely no standard. It's because, one, you got to think about the genre that we just talked about, right? So if you're a rock artist and you're just going in and the producer's essentially setting up the microphones and recording, they're usually getting a work made for hire. If they're more established, then they might get a higher upfront fee and then maybe a little bit on the back. If you're talking about a hip hop artist like we talked about, they're making the beats. I mean, they're owning the compositions. They're owning the sound recordings with you. They're probably getting paid a decent amount up front. Again, it's a wide range depending on their reputation and what you're willing to pay. And then on the country side, I mean, it's crazy the range that I see on the countryside. And it's always, well, he worked with X, Y, and Z, so I have to pay him $10,000 to mix my song. It's just whatever. I can't hear the difference, but that's not my job. So
there are also a lot of people, I'm sorry to interrupt. There are also a lot of producers who had big success in the past, but they're not the, flavor of the week right now. But they still have the sensibility and expertise to help you do what you want to do with your vision, correct?
Right.
So
yeah, and those come down to business decisions more than legal decisions. I help on the contractual side. I can't tell you if it's a waste of money to pay this guy $5,000 and then give him 5% on the back end because he produced the Taylor Swift song 20 years ago. I don't know. I can't tell you that because he produced it. Did it become famous because he produced it? Or did it happen to be famous because of Taylor Swift? And he happened to produce it. And
we know the answer to that question.
What's that?
I said we know the answer to that question.
So I mean that's the thing. So if one guy produced one song for one famous artist once, fine. You got to weigh those things. But again, these things are business decisions, not really legal decisions. I can give you these ranges like I talked about, but for the most part, those are going to be on you.
So could you explain or define for our creators exactly what producer points are?
Yeah, it's very easy. A point is a fancy way of saying percentage. All it means is it's a percentage point. So it's the same. I think people say it in real estate too. When you're getting a loan, you can pay to get a half a point off, and it's just a percentage point of your interest rate. The same thing. It's a point. So they're going to get 3% on the back end of the sound recording. Sometimes they want to try to take a cut of your underlying composition, right? Again, it's a range. Like I said, if it's a hip hop artist, they probably shouldn't take on underlying composition. If it's a producer in the rock realm, absolutely not with your song. So, go ahead.
No, it just gets, especially for people, we have a lot of people that don't live in Nashville. They live in other parts of the country and have careers in other parts of the country. So I think sometimes in Nashville, we all hear so much all the time and are part of things, but when you're not in that mix, it can be hard to distinguish what is this, I heard that, and kind of unrolling that ball of wax. So and
you hear a lot of different things when I hear people who have lived in LA or they work in LA. It seems like producers try to grab a lot more here in LA than when you're here.
But producers, because of the indie market and the free tools and Pro Tools and you can do a tremendous amount of pre-production work yourself and then take it into the studio. So the dynamics have changed pretty dramatically. But going back to a producer, how long should someone work with someone or contract with them? Is there an average? Is it based on a project only? Or if you've got, let's say you have a deal with a label, an independent label, and they're going to let you do your first record and see how it does. And there's a producer for that. Are you obligated to use them for the next one?
Well, it would depend if the label has the power to direct you to use them. Otherwise, no. And again, it's going to be arranged based on your needs and what you want to do. If you want to feel it out, then do a song. If you know them and like their work, and you're you want to save on studio time and cut, all of your songs in 2 days, then you're gonna do an agreement for all the songs. So it's a huge range.
And they should talk to you, right? If there are any questions.
Of course, always. And that's the interesting thing too, is if you're an artist, does the producer have an agreement that they use? Sometimes they do, sometimes they don't. That kind of shows their professionalism, if they have one or not, their experience in the field. And I don't want people to become too cynical, but if they're trying to get away with, if they've been in the business and they're very famous and they've been around for 20 years, a lot of the times what happens is they just say that they don't need it, which is, some of them go by that, it's just the way that it is. But as an attorney, I certainly would never do that. One of the main things that you need to know is with copyright is everything has to be in a signed writing to have an agreement. It can't be an email. It can't be by word of mouth. It has to be a signed writing. So just keep that in mind.
And that's another reason that the split sheets are so important.
Yeah.
And if you go to the MLC or you message us at info@musicrow411, we have samples of those that will tell you exactly how to fill them out. The one point about split sheets that I have heard over and over again in our level of professional conversation and education is that it is absolutely essential that on your split sheet you sign your legal name the way that you are legal. So for me, it would be Elizabeth Raybeck Hall. But people put different things. You could have Da Baby as your moniker as a professional, but you're really listed as Jerome Smith on your bank accounts and with the IRS and all of those things. So
yeah, and a lot of that is going to come down to probably less the legality than the tracking and accounting of it. And I'm sure at the MLC, they're all over that, right? Because that's what they're dealing with all the time. If you put,
because they can't find you. If you listed yourself as Joe Bones, but the other people you wrote with listed you as Joseph Smith, then they're not going to match you up, right?
Yeah, exactly. And that's the key issue. And that's what MLC is working on to fix, which is good.
So let's talk a little bit about, it became popular, I don't know, probably more so in the 80s onward, but producers getting writing or publisher owning just for producing. And if so, how much, should they get, or what's reasonable? I know every case is different, but what would be an alarming statement that someone say, oh yeah, by the way, you need to sign this because I also wrote this? And we've all heard the tales of people sitting in rooms, not contributing anything, and they're getting a portion of the creation so that it will go on the record. But, for people who are just starting out, that can come as a big shock.
Absolutely, yeah. And let me just say this, I forgot to do this whole disclosure reporting. Not good. Supposed to disclose. This is not official legal advice. These are my opinions for everyone. This is not an attorney-client relationship. Reach out to an attorney if you want official legal advice. Always looking.
And they could go to you. They could go to you.
Of course, come to me. Your best decision making. No. So as far as a producer taking on the songwriting side, at the composition, so they're getting songwriting credit and they're going to take on royalties on the composition. Like you said, every scenario is different. Like everything else that we keep saying, it's going to be a feel thing for you. Now, obviously, I'm completely taking out hip hop artists or hip hop producers and pop producers, right? Because of course, if they're making the underlying the beats, the tracks, they're most likely they're going to take some portion of the composition. I think that's for the most part going to be a no-brainer. What I'm talking about is the rock artists and the country artists who are walking into the room and they have already written the song, right? It's done. They've written it. But what happens is they go in and then the producer changes it, right? But they might be elevating it and to your benefit, and you might really be happy with the way that they changed it. So you might be willing to give them a cut in the songwriting, and they might deserve it. So you give them whatever it is that you want to give them, 5%, 25%, 50%. It's a feel. There's no set formula. Now, what you talked about is the other end. The producer is sitting there, or they're sticking microphones around, and then because their name is on the door, or they are who they are, or because you just don't know better, they say that they want to cut and they take cut. And they just don't deserve it. You walked in there for the song, they didn't change anything, they simply recorded it. There's no point really for them taking it. Now, the only other side of that is you might be negotiating with them. If they are very reputable and famous and they do cost $10,000 a song, and they said, well, I'll do it for you for $2,000 a song, but give me 50% of your composition. They might not be in the song doing songwriting, but it's a negotiation at that point. You might be willing to do that.
Well, something of something is better than all of nothing. But once again, the practice has been in Nashville with certain people, not the majority, but, people who are not well versed in their rights and the way things work, which is not always what is spelled out. A lot of seasoned writers know that a certain producer is going to sit there and go, oh yeah, by the way, if you want it to make the record, it's X amount.
Yeah.
And those people it's a personal decision. Once again, is it abuse? Yes. But I would say most people now in today's publishing world don't do that. I think that was much more prevalent in the 2000s and the 90s, where there were some people who were really big just kind of going around, and the publishers didn't like it either because it was carving into their pie.
Right.
So can you, as an attorney, also help writers and creators, bands, structure their own publishing companies? Because many independent artists, and that is the trend, that people are their own businesses. So does your practice also help creators, not just with agreements, but setting up their own LLC or their publishing company, or structuring the business entity that they need to have to be successful?
Yes, I do. The main benefit of forming an LLC is it's a limited liability company. So what you're doing when you create an LLC is you're limiting the liability of your personal assets. So if something happens, if you enter into a licensing agreement for your composition, you're issuing that license, right? The LLC is doing that. If something happens, there's some kind of lawsuit, you're claiming infringement for whatever reason, on your composition, they cannot go after your personal assets. They can only go after the assets of the LLC if everything is run properly. That's the main purpose of forming the LLC. You can run your own publishing company without an LLC. You can run it as a sole proprietorship. The only risk there is you're risking your personal assets if something ever came up. It's just like any other business. You know, if you run a property management company, you basically want to form LLCs for every property that you run. So if someone gets hurt on one property, they can't even go after each property, right? So that's what each one is going to be its own umbrella. As you get bigger, you want to form LLCs. You're going to have a holding company for your copyrights. You're going to have a touring LLC. You're probably going to have a merchandising LLC, and so on and so forth. So, you know, when people reach out to me about forming an LLC, first of all, reach out to me. Don't just take what I'm talking about now, because every situation is different. But it's going to cost you at least $300 filing fee with the Secretary of State, an attorney fee, and then at least $300 a year in franchise taxes to do that. If you are poor and you have no personal assets, I don't know if that's necessarily worth it or not. Again, these are business decisions. You're weighing business risk versus legal risk at that point. If money isn't quite an issue, form all the LLCs you want, and I will help you do that. Of course, let's limit all of your liability. So, you know, that's generally the idea of forming an LLC. The benefit of an LLC over a corporation, by the way, is a lot less formal requirements as far as holding an annual meeting and keeping minutes and all of these things. And then there's tax benefits. I don't claim to be a tax expert, but I do know that as far as LLC is concerned, for the most part, you're generally going to get taxed less than if you have a corporation.
Wonderful. Do you have any jewels of wisdom that you would like to impart sort of on the whole legal perspective for creators? I know you're very astute and you've tremendous experience working with a variety of different people. So can you share your top 2 wisdom or advice tips for people when they are at a point of engaging an attorney and why they should?
Okay. Well, the first one that I was going to do is plug a book. If people don't know it yet, which most of you should, it's essentially the Bible. That gets
Don Passman.
Yes. So everyone needs to get all you need to know about the music business. And one of my, I know I said a lot of missions and things like that, but one of my mantras is you don't know what you don't know, which is why you need to get an attorney when you sense that something's coming up. And one of my main goals here with seminars like this and my other seminars through helping our music evolve and the articles and blogs that I do, you can check out my newsletter on whiskeyGhost.com, is to prepare musicians and small businesses to understand, oh, I don't know this. I do need to go find an attorney. So they understand those things. So with a book like All You Need to Know About the Music Business, you will start understanding a lot more. You'll understand a lot more of the industry standards, and you'll understand when you need to find an attorney. So get that. It's very, very dense. It's extremely dense.
It's in its 23rd printing.
Yeah, it's there's a lot of information in it. Read it. You'll never understand or capture all of the information in it, but then you just use it as a reference. Oh, a manager reached out to me. What happened? And then you go to the manager section. Read the manager section over again. What typically happens with manager? What their normal, commission structure is. And then you can kind of negotiate with the manager before you reach out to me, right? And then you're not wasting, not really wasting my time, but you're not wasting your money. If you know this guy's trying to take 30% commission for 7 years and you don't know the guy, you are way outside industry standard. You don't even have to bother giving me a call. You can just do it on your own. So though, that's the benefit of having a book like that. That's the wisdom that I would.
And so I've read your blog posts. They're very informative and excellent. And they just go to Whiskey Ghost Entertainment Law or just whiskey-ghost.com.
Whiskey-ghost.com. Yeah, the newsletter is right
And if
there.
they sign up, you can sign up easily, right? And just put in your email and then they'll get the updates, right?
Yeah, they'll get the updates. I'm fairly inconsistent as far as posting all the, blogs. I'm gonna really try to do an in-depth royalties one for everybody, because I know that's a big question as far as the breakdown of all royalties. And then another one that I'm gonna do soon, a seminar I talked to you about, is NFTs. Everyone.
Oh yeah, we have a lot of questions about that. So
yeah,
will you come back for a second version or a third version on these things?
Yeah, we'll figure out how to do it. I don't know if we can cross-platform for one seminar, or if I can just do different iterations of the seminar. But I'm still diving into all of those issues. There's a lot of issues, so everyone needs to again, you don't know what you don't know. Most of you probably don't even know what the hell an NFT is and what you're actually selling. So
and you probably don't want to know. It's so complicated, but
but everyone sees the dollar signs, which is great. I mean, if it holds, the system will be great, and if it's another revenue stream for the music industry, excellent. But let's slow down.
That brings up the question, which we don't have time or space tonight to talk about, but cryptocurrency and blockchain and how that is impacting creators and, the safety and escrow of their money and the deliverable financial benefit to them that is not in sort of the marketplace, the system that we know. And that's gaining a tremendous amount of momentum on a global basis with countries whose currencies and governance are not stable. But that's a conversation for another day. I apologize for our technical difficulties on the front end, which was me bumbling with.
So trust me. No problem.
You're what?
I'm the worst with that stuff, so trust me.
Well, normally
no problem.
Normally it works really well. I've got a two rig setup here tonight, but we are so grateful I want to be respectful and mindful of your time. So we're coming up on our hour, and unless we have any other people are saying in the chat they want you back. They want to know more.
Thank you.
They want to know where they can find out. I put that in the chat. But for all of you, and on the replay too, we send out a content piece every Friday. It's called Freebie Friday, and we send the highlights of when we have a live expert session, like with Colin, we will send you a little snippet about what it was about. We'll send you the link where you can go watch it if you weren't able to join us this evening. And it will have his information in there too, specifically, so you can sign up for his newsletter or book a consultation call with him, which he very graciously offered for free. I don't know what you know about attorneys, but usually that's a very generous offer because their brains are rented by the second.
Yes, the point one. Everyone, all the attorneys know point one. So, yeah.
And quite honestly, they spend a lot of time gaining this knowledge and experience and wisdom. So, I can say, as somebody that's been in this industry for 40 plus years, the best thing I ever did was have good entertainment attorneys and good accountants. And then you don't have to look over your shoulder. You can sleep at night, and you know that somebody is truly advocating for you on your behalf. And despite the fact that this was not legal advice tonight per se, Colin has a great deal of wisdom, and his practice is booming and getting very exciting. He's got a lot of fun things coming up that will benefit the creator community here in Nashville. So I encourage you to reach out. Christina's put it in the chat for you, which will take you to his website and how to sign up for the blog, and also to sign up for your free consult call. So I want to thank Colin so much for being with us tonight. It's been an honor and a pleasure. And I do have you recording saying you will come back and talk about more fun things.
No question, no question. I love what you guys are doing at 411, and I'd love to come back. I love doing this stuff. I really do. Anytime. We'll figure out the topic. We'll do it.
We're putting together a lot of different fun things, and I will reach out to you and let you know what those are, but they're collaborative efforts with other people in the community at our level with different expertises to help people. And you would be a perfect person to be involved in that. So I will reach out to you, and I hope you have a wonderful evening. And I will follow up with you soon. So thank you so much.
Thanks,
everybody's saying thank you.
Look, please reach out. I look forward to hearing from everybody.
Okay. Good night, free birds. You'll get something from me tomorrow. I was away last week and I didn't send it. So tomorrow you'll get it first thing in the morning. Thanks a lot, everybody. Be safe and have a great evening. And Music Row 411 loves you, appreciates you, and believes in your gifts.